In January of this year, the Supreme Court ruled in a case called Citizens United. You probably know about it in case you don't. It involves a movie called Hillary, the movie. It's actually a political ad. And it clearly was aimed at denigrating Senator Clinton at the time, making voters ask difficult questions about her. But the simple point is that the Federal Election Commission went after those producers and said that those producers had violated the Bipartisan Campaign Reform Act. These call for, so that law is a comprehensive campaign law, but it required up until recently that people disclose their identity when they are promoting a candidate. And they limit corporate and union funding of these ads. Well, the Supreme Court struck down these two provisions of the Bipartisan Campaign Reform Act. In other words, as you and I are looking at ads today, there isn't a requirement to disclose who is funding the ad. And the limits on corporate spending and other group spending have been taken off, provoking a dissent, just a very caustic dissent by Justice Stevens. And it is worth noting, he says, the majority of the states select their judges through popular elections at a time when concerns about the conduct of judicial elections have reached a fever pitch. The court today unleashes the floodgates of corporate and union general treasury spending in these areas. I wanted you to take a look at that quote. Justice Stevens' dissent is well worth your time if you have a concern about unlimited campaign spending. He had a far-ranging dissenting opinion, as would befit somebody who has spent 35 years on the bench and is about to retire. But he talked in particular, he talked at some point about the selection of judges. And he made a connection between the Caperton case and the Citizens United case. And his point very simply is, forget the glamorous campaigns for senator and governor and all of that. Take a look at your local courthouse and take a look at how people are elected. Your local judges can be bought or can be at least significantly influenced as a result of this decision. All right, and with that in mind, I've gone a little too far. I want to share with you just a series of slides that put this problem in perspective. These are not well-publicized situations, just some case in point to talk about. In Alabama, as you can see here, corporations, trial lawyers, and unions spent nearly $60 million since 1993 in Supreme Court races. In the 2005 and 6 election cycle, candidates for the Alabama Supreme Court seats raised a combined $13.4 million. In Wisconsin, there was a Supreme Court justice who, as a lower court judge, failed to recuse herself in 11 cases involving a bank on which her husband sat as a director. After she was elected to the state's highest court, she wrote the majority opinion in a 4-3 decision in his Supreme Court in 2007. It's a remarkable story for several reasons. One, the influence of outside funding. Two, the elevation of a local trial judge to the Supreme Court. Yes?
Not from the Superior Court.
Oh, excuse me. Stand corrected. You are right. In our state, of course, and others, we have circuit courts, and New York refers to the Supreme Court in New York, and you're right. So we have an appellate judge in this particular case. Nonetheless, a stunning sum of money, and outside the confines of the state. And we had perhaps one of the most remarkable